three-way conversation that is critical. Some of the most significant influences the Charter has had have been mentioned already, include things like its impact on our criminal legal system and on the protection of minority rights. Those are, to me, the two most significant. We've just had an example in the last few weeks in Ontario, at the Court of Appeal of Ontario, where the Charter was front and center in a case regarding prostitution and brothels. And the court concluded that the Charter provides sex workers with the same protection as anyone else who's doing a legal job. And for those of you who don't know, prostitution in and of itself is not illegal in Canada. Nowadays, our criminal cases in general focus much more on the conduct of the government and the police than they used to. And so therefore, the Crown, when proving somebody's guilt beyond a reasonable doubt, is held to account under the Charter to make sure that the rights and dignity of accused persons are not violated. So it keeps them on their toes and making sure that when we convict somebody of a crime that they've had all due process to which they're entitled. And it has effected change on our criminal law itself. For example, one of the early cases under the Charter was the Oakes case. And basically that was the case about a reverse onus. So a person who was in possession of a certain amount of narcotics was required under the criminal law to disprove the presumption that they were trafficking. And under the Oakes test, the court said, no, you can't, somebody is presumed innocent until proven guilty, and we can't put that onto them to disprove their guilt. That's not the way we operate in Canada. That violates several of the sections of the Charter, but presume the most important one is the right to presume innocent in our country, and that's the way it works. So that was an early case. In that case, Mr. Oakes, whether he likes it or not, is studied every year in law school and is like a critical part of the curriculum because that case set the precedent for how we weigh out the rights and freedoms under the Charter against the government's justification for violating rights. And when is it permissible to err on the side of the whole society? And we know we're violating one person's rights, but it's for the good of society. That's what that case is all about, so it's very significant. Having said that the Charter has been so significant in the landscape of rights in our country, there are some challenges. There have been current challenges, and there will be future challenges. And I just wanted to talk about a few. First of all, the Charter is not particularly fulsome when it comes to protecting economic, social, and cultural rights. And if you think about it this way, if a person is hungry, homeless, and has maybe no job, they're not that interested probably in being able to vote or exercise their civil and political rights. So I argue that those rights go hand in hand. You need both civil and political rights, and we also need social, economic, and cultural rights. Now, it's not to say there have not been attempts to amend the Charter to include these rights. There have been two significant attempts in the past, but they have not been successful. There have also been cases where they have tried to broaden out the meaning of Section 7 mostly, which is the right to life, liberty, and security of the person not to be tampered with except in accordance with fundamental justice. I took some liberties because I didn't have it memorized completely. However, so the idea that you need economic security, for example, and unfortunately the courts have not been prepared to expand the meaning of Section 7 yet to include social, economic, and cultural rights very much, especially in the area of financial economic rights. And the example of a case that you know about probably is the Goslin case, where she challenged the social benefits section of Quebec's, how they ran their social benefits and argued it discriminated, not only affected her life, liberty, and security of the person, but discriminated against her because she was young on the basis of age, and she was not successful. So that's something we need to think about in the future, because, and the reason for this, there's a long sort of history, historical reasons for why we don't have economic, social, and cultural rights. It's, you know, it's a small L liberalism document, which means it's very heavily focused on civil and political rights. That's natural. But I encourage people to think about, for the future, maybe we need to look at some of the economic, social, and cultural rights as well in making it a more fulsome document. Secondly, a huge challenge that exists currently and has existed particularly up to date is Section 15 and the interpretation of what equality and discrimination mean. The courts have really, really struggled with this. They even in themselves admit this is an elusive right. They say it in several judgments. And so the resulting principles that have come from the courts to help us interpret this right have made it very difficult for claimants to actually meet all the requirements that are necessary to show that your equality rights have been violated. And to make matters more concerning for someone like me who's interested in human rights, this jurisprudence, case law, has found its way into human rights law. So in other words, human rights commissions under the various human rights statutes across Canada have been turning to case law that interpret the Section 15 of the Charter, and it's made it almost impossible then to use those principles to show that you've been discriminated against in a particular area that's covered in a particular province. And so one of the biggest problems that has recently been ameliorated is that you actually have to show that on an objective basis, so someone looking down on the situation, and a subjective basis, that your human dignity was offended. And I saw a case in British Columbia where a transgendered person argued that they were discriminated against because they weren't being allowed to be a counselor in a rape crisis center, where the court actually said, I cannot see how being discriminated against on the basis of your transgendered status would actually amount to an effrontery to human dignity. And I'm saying to myself, excuse me, how can anyone know what it, personally, how can you judge how that person's dignity was affronted? And when you think about the tradition of how that's a very vulnerable group in our society. And so I found that really troublesome, that of course the court felt it had to follow the precedent that required that subjective, objective human dignity. And that was a human rights case. That was not a charter case. So the second aspect, it is very difficult, the principles under Section 15, is the requirement for a comparator group. So what happens is you have to show that you've been treated differently, right, than another group of people. And the court gets to choose what group they're going to compare your treatment to. And what we've seen happening with regard to this, and it continues to happen. The good news is the dignity part's been thrown out and we've got a better test now for discrimination. The bad news is we still need a comparator group. And why do I say that's bad news? It's because what we see happening in the courts is that they are manipulating the comparator group, and sometimes the way they choose the comparator group has the effect of finding that, well, you weren't treated any differently than this group over here in the way they've chosen the group, and therefore you've not been discriminated against. So it has the effect of influencing the outcome of the case. And so what we need to look at, I think, is to not to say to the courts, you've screwed up so you can't be doing this anymore. What we have to say to the courts is continue working at this. This is very difficult work, and we need to keep working on it, keep amending it, and keep looking at what it is we're trying to accomplish with respect to Section 15. The other, and long, I think this is going to go on and raise. I listened to a Supreme Court of Canada justice speak recently, or just on his retirement, and he figures all the battles have been done on the charter, all the big cases are over with, and from now on it's just going to be fine-tuning. And while I would maybe consider that possible, I think where we're going to see a lot more litigation in the future is competing rights. And the charter itself has got a built-in balance. So if your right has been violated, the government then has the opportunity under Section 1 to defend itself, to show that the law is reasonable and justifiable in a free and democratic society. And I wonder how many of you know that in approximately 40% of the cases that are litigated, the government actually does successfully defend its law. So it's almost a 50-50 thing. So it's not like the charter is, completely not balanced, and we're not looking at the good of our whole democracy, and we're not looking at other rights, because we are. The courts are strenuously looking at that. Where we're seeing some really strange situations is not so much an individual person's violation of their rights as against what's best for our society, and it has to be a good reason. You can't come up with a frivolous reason for violating someone's rights, is where you have two individual rights that seem to be in conflict. And I think that's where we're going to run into some difficulties, and it's because sometimes we have to be really careful as to whose rights we're balancing here. The court's job, the jurisprudence to date is, from the court, is that if you've got two competing rights, they have to be harmonized. So one right doesn't trump another right, for example. However, sometimes the courts really struggle with that, and sometimes we see recent political arguments, including in our current election in Alberta, where a false conflict is created. So the example of allowing, saying that government marriage commissioners can refuse to perform a same-sex marriage because of their freedom of religion or conscience is a conflict, right, between one person's right to freedom from discrimination on the basis of sexual orientation against another person's freedom of religion. And actually, though, if you really think about this, the issue came up recently in Saskatchewan, and the court there said it's not between those two rights. What we're looking at is the gay people's right to access to a government service, which is a civil marriage, without discrimination. It's not about the beliefs of the person who's performing the ceremony. So think about it this way. What if a civil servant said, a couple came in to have a marriage performed, and said, I think you're too old. You guy are 80 and she's 25. There's too much of an age discrepancy here. That's age discrimination, right? And it may not be wise for them to get married, but that's not their role. Their role is to provide a service without discrimination. Or I think we can even point to a real example historically where it was actually illegal for people of different races to get married. That is not the role of the government. And the Saskatchewan court said, if we actually refuse to perform same-sex marriage based on religion or conscience, that offends the equality rights of gays and lesbians. And we cannot refuse them the service based on their sexual orientation. And they also talked about the non-religious nature of civil marriages by very definition. It's not like we're wading in to say, you minister of X church, you must perform. It's not, it's the government. It's a civil marriage, and it's a different aspect. And so in the end, our freedom of religion in this case actually has to yield to the greater public good, which is providing services without discrimination. One other thing I just want to comment briefly, it's not in my notes, but I thought about this a concern that I have is access of the public to making charter arguments in court. This is another issue I see as very, very significant, and particularly in light of the fact that twice we've had two different governments take away the one program that provided funding called Court Challenges. And there is a little bit left in a separate program for language cases. There were always concerns about the Court Challenges program because it only involved providing funding against federal laws or federal activities and not provincial laws. However, I have a deep concern about that because it's so expensive to go to court. There's always a risk that you'll have costs awarded against you. You often have to hire a lawyer anyway, even if you do eventually get your costs back. And so what we have now is a situation where only rich people get to go to court to assert their Charter of Rights and Freedoms. And I think that's really counterintuitive. Now, of course, I think it's fair to say the position of the current government, and I'm not an apologist for one or the other party, I don't belong to any parties actually, is that why fund somebody to strike down the stuff we're doing, basically. And I just see that as absolutely insane because this is the ultimate law of Canada. It is, the Constitution is the supreme law of Canada. It stands for everything we stand for, all our values, and if people can't use it in the way it was intended to be used, then what's the point? That's what I think should be said. So, in summary, I think the Charter has provided a vehicle by which all individuals or groups can assert their rights in relation to the government. It also stands as a statement of the kinds of rights and values that we stand for in this country. And I will be very excited to watch the evolution of the Charter in the future and to watch the nature of the three-way conversation between citizens, the courts, and Parliament and legislatures. And I hope that it will continue to develop and will be used more often. And yay, Charter.
Can I ask a quick question?
Sure, we can
You
do.
have time for just a quick?
Yeah, I'm going to open the floor to questions afterwards, but if it's quick, we can do it now. If you have to go, you can ask it now.
Yeah. Is that okay?
Yeah,
I'm sorry,
sure.
what to- You referred to economic, social, and cultural rights
Correct.
with regard to Section 7.
Yeah.
Could you maybe give an example or give more details about what the economic rights would look like within Section 7?
So, for example, in Canada, you might, there are a few that come to mind, but you might say that in this harsh climate, we need to have a right to adequate housing because we can't live outside, it's too cold. So that would be an economic right. And you would say, the argument would be that your security of the person would include the right to have adequate housing. And that would be the argument that would be made under Section 7. It's awkward. It's the best that people look through the whole Charter to say, gosh, we've got to advocate for this. It's really important, and this is the closest we can come. The only other one that sort of helps at all would be Section 15. It says you have to treat people equally, whether they're rich or poor, for example. But again, poverty hasn't been litigated as an example of a basis upon which we can protect people. So it's awkward. That's why we need to have something more wholesome. And some constitutions do. For example, South Africa recently drafted a new constitution. And they have not only the right to adequate housing, but they also have the right to a clean environment. And those are two examples of economic, social, and cultural rights that have, and they have not fallen apart economically. It hasn't cost them a fortune. There's lots of limits on it, but they believe that these, in that particular country, these are critical rights, and they decided to put it in when they wrote the Constitution. So,
That's great, thank you.
you're welcome.
Okay, I just want to quickly check. Zach, can you still hear us?
I can hear you, but I used to be able to see you. I cannot see you anymore.
I don't know what
Yeah,
happened to the
something-
camera.
okay.
Camera comes
Is
over.
it got a,
Can you guys see me?
Oh,
Yeah,
yeah.
we can see you, but
Okay, sorry. And you
is
can
there
hear me
something
now.
on it?
No, No, it just randomly just stopped.
Well, okay, so the camera died, but at least you can still hear us, so I guess you'll have to do this blind. But next I'm gonna introduce Zach Paikin, who is a grassroots liberal activist.
So there, can't hear you anymore.
Oh, what the?
Adjust microphone settings.
Okay.
Connection.
Lost sound, I can't hear anything you either said.
What about now?
Can you hear us now? Okay, you know what? Maybe I'll introduce Brian, and he can start talking, and then I'll fiddle with this.
Sure.
I wish I was more technical enough logic here.
I'm afraid I'm not either.
And it just stopped randomly.
Okay. Okay. Well, oh, you gotta plug that in.
No, we're not getting visual anyway, so I just don't.
But I think it has the mic on.
It does have.
Oh, there's a mic built into the.
Oh, it's working.
Now?
He
I'm
can,
hearing you.
he can hear us.
Just leave it.
Okay.
Okay.
Sorry about the picture.
Yeah, we don't care.
Oh, it's back on. You got it. You got it.
Okay, cool. So, actually, in that case, I'll just introduce Zach, where I was gonna do that anyway. So, Zach is a grassroots liberal activist and Canadian political commentator. Currently a member of the board of directors of the Mount Royal Liberal Association, he was also a candidate for the national policy chair of the Liberal Party of Canada at the party's 2012 biennial convention. He's a columnist for Canada's iPolitics, a regular blogger for the Huffington Post Canada, and the Canada editor for the multimedia journal Fair Observer, and he contributes research on international affairs to several Washington-based think tanks and institutes. Originally from Toronto, Zach now resides in Montreal. So, go ahead, Zach.
Hi everyone, Natalie, I'd love to look at your beautiful face this entire time, but you can turn that around so I can see everybody else that I'm talking to.
Drop it down.
Also important. Hi everyone, good night. I just wanted to, good evening, I want to thank you all for having me tonight, particularly to Brian Seaman for reaching out to me on this important event, and to my distinguished panelists who are going to be talking as well. I also want to make a very quick thank you as well to Natalie and everybody else out in Calgary with the young liberals who are doing absolutely phenomenal work. Montreal isn't exactly Calgary when it comes to Liberal Party activism, but Quebec is basically Alberta these days. So we've both got a lot of work to do on both of ours. Last time I was out in Calgary actually was for an extended period of time. I was back in 2009 for the Grey Cup. A remarkable game and an incredible celebration of Canadian unity, and I think that it's quite appropriate that the next opportunity, which is tonight, that I've had to sort of talk to people out in Calgary at length as we talk about an issue that should be uniting Canadians. I'll keep my comments very brief so that we can save as much time as possible for questions, comments, stuff like that. I was asked to talk a little bit about Quebec and the National Unity File. I'm dialing in from Montreal tonight. First and foremost, let's dispel a couple of myths that are always brought up about Quebec vis-a-vis the Charter, vis-a-vis the Constitution. First and foremost is that the Charter and the Constitution were unjustly imposed on Quebec and upon Quebecers. That is absolutely false. We had the separatist government of Quebec that at the time was led by René Lévesque, was constantly trying to sabotage negotiations and was the only government that did not want a deal. I'm sure many of you have heard of the Gang of Eight during 1981 negotiations. That was all the premiers of all the provinces except for Ontario and New Brunswick. Those two provinces were allies of Pierre Trudeau at the constitutional negotiating tables. All the other ones, led by Alberta's Peter Lougheed, formed the Gang of Eight. But what was different is that pretty much 7 of the 8 wanted a deal at the end of the day. They just wanted a better deal. The fundamental goal of René Lévesque and his Parti Québécois separatist team that was negotiating there in Ottawa back in November of 1981 was to make sure that there would be no deal. Because the goal of any separatist government in Quebec, and I can attest to this, I live here, is to demonstrate on a constant basis, not just on constitutional issues, but on political issues as well, that federalism does not work. They were never going to sign on in the first place. This entire concept of the night of the long knives in which the Quebec delegation was betrayed is absolutely false. Jean Chrétien was at home and in bed. His wife can attest to that by 11 o'clock that evening when the deal happened well on afterwards. We had Pierre Trudeau was also at 24 Sussex the entire night. There was almost no back and forth that entire night between Ottawa's delegation and the province's delegation. Peter Lougheed himself, the leader of the Gang of Eight, was in bed and was not present during the negotiations. Sterling Lyon of Manitoba didn't sign on either, and in fact his government largely did not sign on. It was in the middle of an election campaign that these negotiations took place, and his PC government was eventually defeated, and it was the government that replaced it that ended up signing on to the deal that would eventually lead to the patriation of the Constitution. So all those myths, to basically state, all these things to say basically that it was not imposed unjustly on Quebec. And it should be noted as well that at that table in 1981, Pierre Trudeau could make the legitimate claim that he spoke for Quebec. In the election that took place roughly 18 months earlier, Pierre Trudeau's Liberal Party won 74 out of 75 seats in Quebec. 72 out of the 75 MPs in Quebec at the time of patriation supported patriation. And Trudeau, just roughly a year beforehand, had also won a very important referendum for the no side on sovereignty association by a huge margin, 60 to 40 in terms of percentage, on the explicit promise that he would be renewing Canadian federalism. And that's exactly what he ended up doing. So, without question, it was not unjustly imposed on Quebec. And back then, in the early 1980s, and this was the case then, and still is the case now, patriation has had an immense level of public support in Quebec, roughly 80%. And the Charter of Rights and Freedoms even greater, closer to 90% support in Quebec. It was the government of Quebec, the separatist government of Quebec, that opposed it, not the people of Quebec. So that's number one. The second myth that we need to dispel all the time is this need to bring Quebec into the Constitution. This is exactly what Brian Mulroney tried to do with Meech Lake. It's what he tried to do with Charlottetown. Not to say that, we can have a conversation about whether it's important to enshrine Quebec's distinct status as a distinct society in the Constitution. That's a completely different question altogether, but the need to bring Quebec in is false because Quebec is already a part of the Constitution. Even though the Charter and the Constitution never received the signature of the provincial government of Quebec, it is still applicable in Quebec. It is the supreme law of all of Canada. The Supreme Court has been very clear on that. And Quebec has used the Charter in many cases and the Constitution in order to advance its own interests, particularly invoking the notwithstanding clause in the past and constantly negotiating and litigating on its premises over the course of the past several decades. So Quebec is very much in the Constitution. And I'm going to use this sort of to lead on to a very brief talk right now just about what I think our future challenges are. We've always had a major challenge in our country in the division between the challenge of keeping the country together, national unity on one end, and then on the other end ensuring the rights of all. Never was this more present at the national level so early on in our history, in my opinion, than in the 1896 federal election, in which Charles Tupper of the Conservative Party squared off against Wilfrid Laurier. The Liberals ended up winning, but the major issue of that election, and that was the first of Laurier's four majorities, the major issue of that election was the Manitoba schools question, in which the Liberal government, regrettably in Manitoba, had legislated out of existence sectarian schools, notably Catholic schools, because Catholics were the majority at the time. They legislated out French as an official language of Manitoba, and the result of those two policies was basically the death, so to say, or a near extinguishment of the Catholic and Francophone populations of Manitoba. And unfortunately at the time, we could only assure one or the other between national unity and the rights of all. We had the Conservative government at the time that wanted to reverse the Manitoba government's legislation by imposing remedial legislation at the national level. That never got through, and the Liberals filibustered. And Laurier ended up winning the election, managed to keep the country together as a result. And the country we have today is largely thanks to him, but at the same time, we had to sacrifice a certain element of our population and their rights in order to do that. The Charter, and I think that this is one of its most enduring legacies, is that we no longer have to make that decision between rights and national unity. I think that's a remarkable testament to what the Charter actually represents, because it enshrines not only the rights of all Canadians, obviously subject to reasonable limits as demonstrable in just and free democratic society, but still enshrines the rights, but it also enshrines the rights to be Canadian. And that's fundamentally important. Without the Charter of Rights and Freedoms, without the patriation of the Constitution, without the amending formula, the reference that the Supreme Court of Canada put forward in 1998 on the secession of Quebec never would have been possible. The Clarity Act hence would have never been possible. And a whole variety of acts of keeping the country together over the long term never would have been possible. Now, just because, however, Quebec is already within the Constitution doesn't mean that we shouldn't be talking about bringing Quebec in to the political fold. The constitutional fold is already a part, but we should be talking about bringing Quebec into the political fold, and this is why. There are so many fundamental challenges that our society is going to be facing off against in the upcoming decades. We are facing off against an unbelievable demographic shift, in which over the next 20 years, the percentage of the population in this country that is 65 or older is going to be increasing from 12% of the population to 25% of the overall population. We've been having a debate on old age security recently at the national level. That's a program that's going to, as a result of this demographic shift, cost 3 times as much. And unfortunately, roughly only half as many people will be able to pay it, because as a result of this demographic shift, the proportion of available workers, the ratio of available workers to retirees, will be shifting from where it is today at roughly 5 to 1 to only 2 to 1 by the early 2030s. And it should be noted that all regions need to be on board for any potential reforms that we invoke, especially the healthcare, because healthcare is by far the most expensive program with regards to what's going to suffer from the demographic change. The old age security and pensions is going to be dwarfed, trumped completely by the healthcare debate. Healthcare, as you all know, is the delivery of healthcare is a provincial responsibility. It's a provincial jurisdiction, but it's the feds that provide a lot of the cash. It's an issue where all the regions of the country need to be working together to find ways of how we can reform our current incarnation of our healthcare system. And so bringing Quebec into the fold, bringing everybody into the fold, is going to be unbelievably important. That's number one. Number two, over the decades ahead, we're going to have an unbelievable intersection, and this does not happen very often, on the global stage between two facts. Number one, environmental and climate change. And number two, is a geopolitical shift in which countries like China, India, Russia, and Brazil are going to have as much, if not more, influence than the United States at some point on the national stage. Likely by the middle of the 21st century, this could be the case. This is going to be the case in issues of economic importance and issues of international security. And as climate change continues to cause the Northwest Passage to thaw, this is a passage through many Canadian islands in the Arctic, that greatly reduces the distance from the northeast of the United States to Asian markets. If you go north through the Northwest Passage as opposed to the south through the Panama Canal, so huge economic incentive there. The fact that it's thawing, coinciding with the rise of China and the irredentism of Russia, is going to cause a more likelihood of conflict in the future. We're going to have to find ways to defend our north, whether that means doing so militarily or at least going to the table and making sure that we negotiate a deal that works between us, the United States, and the Russians, to make sure that there's no unjust seizure of territory in the north, which would be an unbelievable destabilizing act for the entire continent. I don't think that it's not possible. We've become very much complacent with our peaceful way of life in the 20th century. However, in every single century beforehand, in the modern history of our continent, there has been land warfare on the North American continent. And with 25% of the global world's oil reserves located in the Arctic region, it's no secret that there are many countries, particularly the Russians and the Chinese, that are interested. And so every region is going to have to be on board. We're going to need to have a government that unites all parts of the country if we're going to be able to populate and defend the North. That's exactly what I think that the government in Quebec and Jean Charest is doing right now with this Plan Nord, and other regions have very much to contribute in the front as well. Finally, we're going to need to have every region on board if we're going to have to talk about a wide variety of other issues, whether it's other political issues, talking about generating more revenue, and that could be through, as we have in the West, natural resources. It could be through increased other forms of economic productivity or technology or manufacturing in other parts of the country. But everyone's going to have to be on board, and there's going to have to be a policy at the national level that's consistent with liberal values, but at the same time does not prevent our ability to deliver real results for Canadians, generate enough revenue so that we can address the challenges I was just talking about with debt, because healthcare costs are going through the roof, because defending the norm is going to require a lot of investment and a lot of revenue. And finally, of course, constitutional issues. Everyone's going to have to be on board if at some point, and I don't know when this is going to happen or if it's ever going to happen, but if we want to open up the Constitution once again and talk about issues that I think are of fundamental importance, say democratic reform, electoral reform, and renewal.
What guys are talking about the
right
charter?
now, and I don't have to appreciate
They're
the
talking
clarity
about
we've
the
seen
charter.
Stephen Harper's managed to do with the state of our
It's almost
democracy
done.
over recent years. We could talk about other issues on constitutional fronts as well. We could talk about the monarchy, the future of that. We could talk about another more comprehensive powers package
He's out of
between states and
control.
provinces. All this to say that everyone's going to have to be on board. I'll close with this. I had a great and distinct opportunity over the course of last fall and the early winter to travel the country from coast to coast, literally from BC to the Maritimes. And a great opportunity campaigning for National Policy Chair of the Liberal Party. And what I noticed first and foremost is that Liberals, and by extension Canadians, because it wasn't only with Liberals which I was interacting, really share the same values. I think that's an unbelievable testament to the fact that we have such a diverse, broad, pluralistic country, geographically diverse, ethnically diverse, culturally diverse on so many fronts, yet at the same time, we're a very moderate population, and there's so much more that unites us that actually divides us. I say this because there's a constant myth put forward by Quebec separatist politicians that the values of Quebecers are fundamentally different from the values of Canadians, that Quebecers are naturally more collectivist than Canadians. That's absolutely false. Once again, it's another myth put forward by separatists, in addition to all the other myths that I was stating before. Look at some of the facts, and I'm not saying, whether you agree with this or not, I'm just saying look at some of the facts. The population, the province's
I
population,
talked about the charter. He's lost
is the
control.
most willing to consider banning Islamic face veils, the burqa, the niqab, etc., is Quebec, right? The old saying is multiculturalism is not a Quebec value. I beg to differ, but at the same time, they have a different view of what pluralism and multiculturalism is. But it's clearly not the more left-wing or collectivist of the options that's up there on the table. The province that is the most, and this is population, polling shows, it's not the government. The province that is by far the most supportive of free trade with the United States, has been historically, still is now, is Quebec. The province that is the most supportive of trying to open up its healthcare system to private health insurance is Quebec. User fees and extra billing is also most present in Quebec than it is in any other province in Canada. And the benefits, for example, of other social programs like welfare are considerably lower in Quebec than they are elsewhere in the rest of the country. So this idea that Quebecers are a bunch of lefty pinkos is absolutely false, that their values are different. All Canadians share a broad set of values, and we need to tap into that if we're going to be able to find a way to bring the country together politically. If not constitutionally, that's already been accomplished thanks to Pierre Trudeau, but now we've got to bring everybody together politically. That's a challenge over the next few decades that not only the Liberal Party will have, but that all parties will have, and I look forward to working with you over the years ahead to make that happen. So thanks for having me, and I look forward to your questions.
Move on.
Thanks, Zach. Okay, so I'm just going to introduce our last panelist now. We have Brian Seaman here. Brian has been a research associate at the Alberta Civil Liberties Research Center since November of 2004. He has two major works in progress for the center. One addresses the limits to multicultural accommodation in a liberal democracy, and one addresses the increasing surveillance of our private lives and dwellings by agencies of the state, often rationalized as necessary intrusions in the interest of fighting crime or preventing acts of terrorism. In addition to writing for the ACLRC, Brian's articles and commentaries have appeared in dozens of print and online media sources in Canada, South America, and Europe, including Law Now, the Aveledo Parrot Family Rights Journal, Migration Letters, the Calgary Herald, and A1. So, Brian?
Well, thank you very much, Madam Chairwoman. Thank you very much, Zach, for your commentary, and Linda, thank you for your succinct and broad overview of the Charter of Rights and explaining about how there is no right that predominates, that increasingly, as our society becomes more and more complex, we will see increasingly disputes between different rights, and the role of the courts will be to find a way to balance these rights and create a better and more democratic country for all Canadians. Zach spent some time debunking the myths surrounding the patriation of the Constitution and the fact that Quebec didn't formally sign on politically to the Charter of Rights, and explained that Quebecers still are, of course, subject to the Charter and indeed enjoy the same rights as all Canadians. I think it's important to debunk another myth that I identify as not coming predominantly from Western Canada, but it does seem to find a certain resonance here. And it's this myth which I have heard throughout my adult life, that the Charter of Rights and Freedoms was somehow some kind of a foreign document rammed down the throats of Canadians, and indeed was antithetical to Canadian values. So what I'm going to do is I'm going to step back. Linda's already provided I think, a very excellent broad overview of the Charter. I'm going to step back a little further and give my thesis. And my thesis is that the Charter of Rights and Freedoms that was brought in 1982 was not indeed some radical departure from Canadian constitutional tradition. In fact, it represented an important evolutionary step forward and was part of an evolutionary process, and that the seeds, or the genesis, if you will, for the Charter of Rights and Freedoms could be found in the original constitution of this land of ours, which would be the British North America Act, or the Constitution Act as it was renamed in 1982 with the patriation of the Constitution. Canada traditionally was comprised of three major groups: the First Nations, or original inhabitants, the descendants of French settlers, and the descendants of the English. And that's not to say that things were absolutely harmonious in the decades preceding the coming together of Upper and Lower Canada and the maritime colonies to form this homeland of ours that we know as Canada, because there were rebellions in Lower Canada and in Upper Canada, and indeed there was friction and tension between the French and the English in Quebec. However, the political engineers of the day, Georges-Étienne Cartier in Lower Canada, which is now Quebec, of course, and John A. Macdonald in Upper Canada, were able to cobble together a union that dealt with the issues of the day. They found a way to meet the needs and the rights of the French and English speakers of this country, and indeed the seeds for bilingualism were set out in the original document that was indeed the original Constitution. Section 133 of the British North America Act addressed bilingualism in the legislature of Quebec, and allowed for bilingualism in the federal parliament, and indeed in all federal courts, not only the Supreme Court but all courts that were appointed by the federal government. We have had a tradition in this history, and the history of our country, of persons fleeing countries, seeking refuge in this country, and there have been some acknowledged successes with meeting the needs of people. For example, the Irish were able to migrate here, and although there were some tensions at the time, they were able to adapt very, very well to this country. Unfortunately, the Canadian record is not unblemished in terms of its accommodation of refugees fleeing persecution. We have had periods in our history where there had been racism. We had the Chinese head tax, which was in existence. Linda, please correct me if I'm wrong, which was in existence in this country until well into the 20th century. I don't believe it was repealed until the 1920s. There was persecution and racism against the South Asian peoples who came to this country. So, and obviously during the 1930s, when Jews were attempting to flee Nazi persecution in Germany, Jews were not allowed into this country. So I think we have to acknowledge, as we admittedly and proudly celebrate the Charter of Rights and Freedoms, and we acknowledge that we are moving forward and becoming a fairer and more democratic country. I think that it behooves us to recognize the times in our past where Canadians have not always been so accommodating. I think it was very important for Bob Bray to refer to John Diefenbaker's Bill of Rights in 1960, because we need to acknowledge that, as Bob Bray has done, that there is a tradition in this country of political parties, irrespective of their political ideology, at least recognizing the importance in theory of equality and equality of rights. The realization and practice of equality has left something to be desired sometimes, and I think we need to acknowledge that in order to move forward. The document that we are proudly celebrating today, this Charter of Rights and Freedoms, has been, of course, credited to Pierre Trudeau as arguably his greatest legacy. Indeed, some historians would say it is his legacy. It's important to recognize that the process that led to this, the implementation of this document, the adoption of this document, involved widespread consultation. Hundreds of lawyers were involved. There were feminist advocacy groups that were involved. There were politicians of all political stripes, progressive, conservative, liberal, NDP. So it did indeed represent the apotheosis, if you will, of a wide array of opinion. And it is not a foreign document to the Canadian tradition. It is a document which I think comes from Pierre Trudeau's admittedly his educational background, and also I think reflects the unique legal makeup of the province of Quebec. Because unlike the rest of Canada, Quebec has its own unique civil code where the values and rights that were evolving in the English-Canadian legal tradition, for example, the right to counsel upon being arrested, freedom of speech, etc. These rights are indeed codified in Quebec. So for Pierre Trudeau to have brought to us a codification of rights does not indeed represent a radical departure. The exception would be, I think, Linda, correct me if I'm wrong, but the exception would be Section 15, the equality section, which did indeed represent something very unique and something very new. But that didn't come into power until 3 years after the patriation of the Constitution. That equality section, of course, has been used, and obviously rightly so, by so many groups, which our current Prime Minister has disparaged as special interest groups. The disabled, elderly people who are fighting ageism, age discrimination in the workplace, women who, as recently as the 1980s, didn't have access to free and safe therapeutic abortions. All these so-called special interest groups have used the Section 15 to fight to obtain their equality under Canadian law. And I think that's important to recognize as well that I have to step off page here for a moment because I mean, this, and as Linda pointed out, I mean, I'm not speaking as some partisan here. I mean, when I heard Stephen Harper before he became Prime Minister, a few years before he became Prime Minister, he's speaking to $1,000 a plate Republican dinner down in the United States. And by the way, I have read that the United States was the only country that Stephen Harper visited before he became Prime Minister. And at this very famous dinner, he infamously described Canada as a second-rate Northern European type of socialist country, and he described the Charter as a flawed document. Well, you know what? I don't hear that when I go away to speak at conference. And by the way, I know that there are all kinds of people who would consider me to be some kind of an elitist because I have a higher education. Well, you know what? This elitist flies down to places like Buenos Aires, a 17-hour flight in economy class, in cramped seating conditions, and I go down to these places and I listen to my colleagues, my age and older, who can tell me stories about when they lived through a dictatorship where there were police who would just come barging into their offices and haul off one of their colleagues, or you didn't know if you showed up to work that day whether you would see one of your colleagues because you would hear from somebody who would whisper very friendly, well, she disappeared last night, or he disappeared last night. I have never heard anyone in Argentina or Italy or any other country where I've ever spoken about the Charter of Rights and Freedoms. I've never heard anyone speak about Canada in anything but the most glowing terms, and they pointed to the Charter of Rights and Freedoms as a model for democratic governance in the world. So I think it's very important to recognize that there is a concerted effort amongst some politicians in this country, certainly the current federal government, to demean and degrade this document for whatever reason. I don't know. I do think that we'll probably have some people who have some questions, and I would like to carry on a conversation amongst Zach and Linda and I. So I do want to just finish off by pointing out that there are so many areas where I see concern for what the federal government is doing in terms of violating the Constitution, violating the Charter of Rights in particular, but I've chosen to limit my comments to one, and that is a refugee law. The federal government has a bill that, if it is adopted to law, would indeed create an entirely new category of refugee that does not exist at international law, the designated foreign national. The designated foreign national is going to be anyone who came into this country by way of human smuggling. Okay, two things. First of all, refugees only form a small proportion of the hundreds of thousands of immigrants who come to this country every year. Secondly, they form only a small proportion, a small fraction of the total number of refugees who come to this country every year. If you're desperate enough to pay money to a human smuggler to ride in the hold of a ship for 3 weeks, lying in your own feces in a stinking hold of a ship to come to this country, I doubt, first of all, that you're a criminal. If you are a criminal, we will be investigating you. But most people who come to this country are desperate to get into this country. They paid money to a smuggler because they're desperate to get out of the country. To penalize these people, which, by the way, this proposed bill that the Harper government is proposing to bring into law, to penalize these people by holding them in detention centers indefinitely, and they can be held indefinitely for years without the right to counsel, without their liberty, to me is akin to, it's illegal in this country to, here's the analogy I want to make, it's illegal in this country to practice loan sharking. The criminal code defines loan sharking as you lending money at a rate of 60% or higher. So, to go after people who are desperate enough to pay money to a smuggler, a human trafficker to get into this country would be like us saying to somebody who's desperate enough to borrow money at criminal rates of interest, you know what, we're not only going to go after the loan shark, but we're going to go after you. And we're going to, even worse, we're going to detain you indefinitely for years, and you're not going to have a right to counsel. This is wrong under Canadian law. It flies contrary to Supreme Court Canada decisions, most famously the Singh decision, and it is also a violation of international refugee law. And the only reason I can think of is